Foreclosure Defense Attorney Richard Shuster. Today's foreclosure defense topic is, now that I'm in a trial modification, what's going to happen in my foreclosure case? If you're in a trial modification and you don't have a lawyer, you need to be very vigilant and careful, because the bank's lawyer may have no idea that you've made your first trial payment. I've been in court when homeowners without a lawyer have their cases called for summary judgment, and they stand up and tell the judge, I'm in a trial modification, I've made my first payment. And the judge and the bank's lawyer say, we're here for summary judgment. There's no evidence in the record, and they grant a summary judgment against the homeowner and set a trial date for 90, 120 days down the road. And the judge and the homeowner just hope that the bank will dismiss the case before the sale and cancel the sale. I'm here to tell you that that's probably the worst thing that can happen in your case, because if you are in a trial loan modification, the bank has no business asking the judge for a summary judgment against you. If you are in a trial modification and a summary judgment hearing is set in your case, you need to go to the website www.nationalmortgagesettlement.com. That's www.nationalmortgagesettlement.com. And if your loan servicer was one of the 5 largest loan servicers that participated in the National Mortgage Settlement, that's Bank of America, Wells Fargo, Citi, Chase, and GMAC, which is now known as Ally Financial. If one of those 5 servicers serviced your loan under the National Mortgage Settlement and the consent judgments that were entered against each of those banks, the bank is not allowed to continue to prosecute your foreclosure case if you are making active monthly payments in a trial modification. So what do? You need to print out the consent judgment that's on the National Mortgage Settlement website for your respective bank. Bring that to court, bring the judge a copy of the loan modification trial mod that you and the bank have signed, and bring him proof that you've made payments as part of this trial mod. Bring them the canceled checks or some receipt from the bank. And if you have those things, and explain to the judge that they are not allowed to continue prosecuting this case, that they've entered a court order agreeing not to do that, then that summary judgment hearing should not go forward. You do not want a sale date 120 days down the road that you hope the bank will cancel. You want the summary judgment to be taken off the calendar or denied. If you have additional questions about this topic or about your particular case, feel free to visit any of our offices in Miami, Fort Lauderdale, the Space Coast, or Jacksonville, or give us a call at 877-511-STAY or 321-622-5040. Visit our website, www.attorneyforeclosuredefense.com, or just drop me an email at foreclosuredefenselaw@gmail. Thank you. Where homeowners fight back, particularly when they hire counsel, banks often make an offer of cash for keys to get a case settled. Sometimes it's $1,000 or so. We've had files where it's north of 10 grand.